Hi, everybody.
Hey,
Welcome to this live stream entitled Antitrust Major Developments in 2024 and Outlook for 2025. My name is Julie Savarino. I am the LinkedIn producer and host, but I am thrilled to be joined by Satya Marar. Satya, thank you so much for being here today.
thanks for having me.
So, if you don't know Satya, he's very impressive. He's an attorney admitted to the Supreme Court of New South Wales in Australia. He also holds a master's degree in economics from George Mason University. Currently, Satya is pursuing his LLM in US law at George Mason. At the same time, he's serving as a visiting postgraduate fellow at the Mercatus Center at George Mason, where he was a former fellow. So Satya concentrates his research and studies in three main areas: innovation, competition, and governance. He studies U.S. antitrust and competition policy, intellectual property, trade, and technology policy. He also previously worked at the Reason Foundation and the Australian Taxpayers Alliance. Please join me in welcoming him.
Hey, thanks so much for having me.
Thank you. So quickly, I wanted to mention, in addition to all his other very impressive credentials, Satya's written two really great articles lately. The first is titled Artificial Intelligence and Antitrust Law, a Primer, widely read. The second is entitled Key Antitrust Developments in 2024 and Prospects for the Coming Year. What I'm going to do is post those in the comments so any of you who are interested can read them. Quick housekeeping, and then we're just going to dive into it. If you'd like me to pose a question to Satya at any time during this live, go ahead and look up to your right. If you're on a desktop or a laptop, you'll see the comment box and go ahead and type your comment there. If you're on a mobile, look down and you should see the speech bubble and you can go ahead and type a comment or a question in there. But with that, I would like to go ahead and ask Satya the question number one, and that is, please talk about what the FTC is currently focused on and what's in their pipeline that's going to impact the incoming Trump administration in January. And then after that, if you could talk about some of the major DOJ things in the pipeline.
Yeah, sure. So, in its sort of final days, the Biden administration era, FTC is trying to get a number of actions through, start a number of new lawsuits, which it knows that the incoming administration will have to take on and either move forward with, or if they want to get rid of them, to kind of do so publicly. So it's you could kind of look at it as a way for Chair Khan to kind of stamp her legacy and make sure that it stands as far as she can have it stand. So they recently filed a case, for example, against Southern Glaciers, which is a distributor of wine and spirits, saying that they violated a 1930s era law that makes it illegal to basically sell your product at a cheaper price to larger retailers than you would to a smaller retailer, with a few defenses and exceptions. And what's interesting about this law, it's called the Robinson-Patman Act, I've written on it, is that it's the only law that's on the books right now, a competition law, that is explicitly designed not specifically to protect consumers and the competitive process, but rather to protect smaller competitors from larger competitors. And we know well that when that happens, it's less competition because you're kind of trying to advantage one firm over the other artificially. And we know that the two Republican commissioners on the FTC opposed this lawsuit being brought because they were, well, partly because they're worried about the impact it would have on consumers, and partly because they didn't think the FTC has a huge prospect of success. At the end of the day, it is kind of strange for the FTC to go to court and argue that there's a market here for alcohol that's shared by head-to-head competitors, being the big supermarket and grocery chains versus small independent boutique stores. Because I think most of us go down to a kind of boutique alcohol store because they have a different product selection, because they're looking for something different, because it's a different experience. Because conversely, they've gone to court when they were litigating the Kroger-Albertson merger, the two supermarket chains. They were claiming that these are the relevant market are just supermarkets. It's a separate market if you include Walmart or these superstores, or include Trader Joe's and Whole Foods. So it's interesting because they're kind of arguing different theories where it basically suits them. So there's that case. It may not continue under the next administration. We'd have to see. Conversely, A lot of the cases against large tech firms, we expect that to continue. We know a number of them were actually begun under Trump 1.0, including the Google cases, the one on digital advertising, which we're waiting for a verdict on, and the one on the Google search case, which was a ruling in favor of the DOJ. This came out recently, and it was kind of a surprise ruling because what they were basically saying is that it's illegal for Google to have agreements with web browsers to make the default search engine Google, saying that this prevents Google's competitor search engines like Bing from gaining economies of scale and prospering. Whereas in Europe, when they had a similar rule against Google, preventing it from having these agreements, most consumers still continue to switch to Google because they just prefer Google. So really, the only people who are going to significantly lose out, it looks like, likely from this, would be the web browsers because they're going to miss out on that $40 million a year, whatever the revenue is that they were getting under these agreements with Google. So it's interesting. We know that the Trump administration is going to continue with these sorts of cases, but also we know they're more pragmatic. So, for example, the current DOJ has asked the court to force Google to divest itself of the Chrome browser and of its search engine. And that's a really extreme remedy that would really undermine and destroy many of the efficiencies that make Google what it is. Whereas Donald Trump has personally said that he's against breaking up Google because he doesn't see that as being practically a good outcome. So we expect to see more pragmatism across the board. We expect to see a more pragmatic approach to merger enforcement. We know the current DOJ and FTC have both put out merger guidelines, which provided very little clarity as to what mergers would or wouldn't be challenged. They have advocated for theories of harm that are kind of spurious and would not hold up in court, and said, look, regardless of this, we might very well come after you and lock you up in litigation. And these guidelines, even though they've disregarded a lot of legal precedent and courts haven't always been receptive to them, they've had the effect of chilling merger activity by creating uncertainty. A number of deals don't leave the boardroom because, well, it's going to cost us a lot of money to fight this if the FTC challenges us. So we have to be careful and put this off or not do this at all. And so you've seen a number of small companies be affected by this because they have less prospects being acquired by a larger firm, which means that their technology might take longer to deploy, and entrepreneurs might have less of an incentive to leave their cushy job at a big tech firm, strike it out on their own. Because for many of them, getting acquired is an off-ramp that incentivizes them to create something and build something new. So even though we expect the agencies to go hard against big tech and to support little tech, which is what Trump has alluded to in his tweets about antitrust, we do expect them to be more pragmatic about how they do it, to generally have a more business-friendly climate. And we would hope for a withdrawal of those merger guidelines because they've been touted as a success story by the agencies, saying, well, so many mergers, we don't even have to fight them anymore because companies decide not to do them. Well, the job of the agencies isn't to stop mergers. It is to stop anti-competitive mergers, or ones that are likely to be anti-competitive. If parties are abandoning deals simply because, well, we're going to get sued and it's going to cost us millions and millions of dollars and a lot of bad PR or press, so we're not going to do it, that doesn't necessarily mean consumers are better off.
So in terms of the merger guidelines, those promulgated by both the FTC and the DOJ, the new incoming chiefs of those divisions could just withdraw them or abolish them? They have the power?
Yeah, they could vote to withdraw them because the guidelines don't really have the force of law. They're more of a guidance telling private parties how the agencies are going to approach merger enforcement, to give them some idea. That was always the purpose. Courts have sometimes deferred to the guidelines, but they don't have force of law. So if there's a guideline, for example, that ignores legal precedent, then a court may simply say that's not correct, we're not going to go with it. And what's interesting is when they've gone to court and fought these cases, they even had some success, but not using the guidelines, but using very conventional standard theories of antitrust, which existed before these recent guidelines. What we'd hope to see is if the guidelines get revised, which is possible, then there'll be more of a focus on the tools of economic analysis and more of an acknowledgement, as we had in previous guidelines, that although mergers can certainly be anti-competitive, in many cases they can be pro-competitive. And there are certain signs they can look for that make that more or less likely.
And this goes to the policy decisions of the new leaders of those two divisions.
Yeah. Elsewhere, where they have things like new rules which have been formally adopted. So, for example, there's a non-compete rule. So the FTC put out a blanket ban on all non-compete agreements. And these are really unpopular agreements. Workers hate them for good reason, right? But in many situations, they kind of might make sense, because if you're going to invest a lot of money in training somebody new, giving them all these skills and all this insight, you don't want them going off too soon to start off their own thing and benefit off that, because that discourages you from training them in that way. They say, well, you can just have trade secret laws to protect any sensitive information, but well, number one, that isn't always super effective for doing that. But number two, trade secrets kind of discourage knowledge dissemination compared to other options. So what we have is every state takes its own approach to non-competes. It's always been that way. It's been kind of a state thing. Some states take a very permissive approach to attract more business investment. Other states take a very liberal approach so they can encourage more workers to come in and have a more innovation-oriented climate. But the FTC rule would basically ban them across the country, with the exception of senior executives. And their legal authority to actually pass a rule like this is very questionable. The FTC, under the law, really has a lot of authority to pass rules governing consumer welfare, consumer protection matters, but not so much to dictate what is or isn't a competition rule. Usually that has been the purview of Congress. So we could expect something like that to be potentially rescinded, either if not internally through the agency, then through a challenge. So there's the Congressional Review Act, which requires all new rules to be reported to Congress within 60 days. We could see the non-compete rule subject to that potentially, if courts have already ruled that it's unconstitutional, but or it's illegal. But there's challenges. There's an appeal to that's ongoing. There's also the rule they put out on the filing guidelines for mergers, the HSR rules. And these have been a bit controversial, because they would drastically increase the scope of disclosures that firms have to put in if they're merging, increasing time and costs to provide more documents, more information. That would increase the cost of deal making, but more so, it would also put a lot of strain on agency resources from reviewing more documents, from going through more material. And that might lead to less resources available for the agency's other priorities. So this is another rule that might go through the Congressional Review Act review, and the Trump administration could like to freeze it for about 60 days before it's officially adopted. But we'll have to see what happens.
So the FTC, there are three rules that are basically could be on the bubble and on the chopping block. One, or a change. One is the non-compete. The other is the guideline for mergers. What about the pre-notification rule?
Yeah, so that's what I just mentioned earlier, the HSR, Hart-Scott-Rodino Act, pre-merger notification rules. Yeah.
Okay.
So, like I mentioned, though it could be subject to the Congressional Review Act. It could where if both houses pass a vote of disapproval, it could be rescinded. But it's questionable whether that will actually happen, because unlike the merger guidelines, the Republican commissioners have not really been critical of these new rules. In fact, they voted to pass them. And Commissioner Holyoke, she came out saying recently, she's a Republican commissioner, she came out saying she wants to wait and see what the impact of these rules will be. Because, in theory, having more disclosure would allow the agencies to better identify what cases to bring. And they've also included in the new rules, they basically said, okay, you're giving us more information, but counterbalance that, if we end up thinking still that your merger probably doesn't raise anti-competitive concerns, then we'll let it go ahead earlier on. So I do think, though, that there'll be a lot of pressure from business to push against these rules. So the Trump administration might just go ahead and freeze them, or try to not get them through Congress. But the commissioners, at least within the agency, I don't think there'll be a move to scrap them very soon.
And they can't be changed by executive order?
No. My understanding is they can't.
Okay, so in terms of merger enforcement, talk about that a little bit, would you please?
Yeah, sure. So I mentioned the guidelines and how they're kind of very aspirational. The current DOJ and FTC have a philosophy oriented around Neo-Brandeisianism, this idea that big business is inherently bad. And the goal of antitrust isn't just to protect consumers, it's to protect small businesses. It's to protect other sort of social policy goals, including labor rights and the environment and so on. Not that those things aren't important, but you have agencies directed at labor that deal with that. You have laws passed by Congress that deal with that and with environmental issues. Um, as far as competition goes, the understanding since the 70s has always been that the goal of markets is to serve the consumer. And so we expect to see a return to that in merger enforcement. What I will say, though, is, and I alluded to this before, in the last few years of the Biden administration, the cases that they've decided to bring have ended up being more oriented around traditional theories of antitrust. And this isn't so much because they have abandoned their ideology. This is because they've realized what is likely to work or not work in court. So they had some victories this year. They managed to block the merger of two fashion brands, Tapestry and Capri, on the basis that it would lower head-to-head competition in the market for affordable luxury handbags. So that's a very standard, straightforward kind of antitrust case. But then elsewhere, they kind of have made arguments that are completely outside of traditional antitrust. So, for example, when they contested the Kroger and Albertsons merger, which the parties eventually decided to abandon voluntarily, one of the arguments they made was workers will be able to make less money because there'll be fewer businesses vying to hire them. And this is interesting because it's a purely labor-oriented argument. You can certainly make the argument that if the demand for hiring or investing in labor is less, that could lead to consumers being worse off because the quality of services go down. This was an argument that was made in the merger of the two publishing houses, Penguin and Random House. The author Stephen King actually testified in that DOJ case and said, well, if these two companies merge, authors are going to get lower advances. And if we get lower advances, that discourages us from going into writing. And so consumers are basically worse off, was the argument. That's a different argument to saying, well, workers will get paid less, because workers getting paid less could mean that consumers pay less if those costs are passed on to the consumer. So I think under the next administration, we would expect to see fewer of those novel arguments and more orientation around the bread and butter of the agency, which is to protect consumers, to go after cases that are likely to be anti-competitive or violate the laws, rather than simply trying to establish precedents for aspirational changes in the law that don't reflect what we see in the last few decades.
So you and your colleagues are anticipating more of a return to traditional antitrust definitions, protect the consumer.
Yes, but where we do expect to see some leeway is in the tech sector. Commissioner Ferguson, who's now going to be appointed as the FTC head, he has repeatedly said, look, my views on this topic are nuanced because I see we're dealing with very different economic conditions to what we were dealing with in the past. We have big tech giants, which in some countries are viewed as gatekeepers, your Amazons, Googles, Facebooks, and so on. And so there's more pressure to kind of crack down on some of their business practices, which might be more efficiency enhancing. But the argument is that, well, once they corner a section of the market and everyone's reliant on these platforms, they can abuse that monopoly position to harm consumers or to harm their rivals. So I do think there'll be some attempt to push the needle on that. We know, for example, they're trying to, and they've been trying to do this for the last few years, unwind the merger of Meta with Instagram and WhatsApp. And they've been criticized in court for this. The district court judge came out saying, you're defining the market so narrowly that it strains the antitrust precedents that we have in this country, because you're kind of ignoring competition from other apps like LinkedIn and X and so on, and YouTube and all of those. So, I think in the big tech area, expect to see more cases coming and expect to see these cases pushed. But on the whole, a more business-friendly climate for mergers, a more pragmatic outlook on what cases get brought, and I think less use of rulemaking to kind of, for the agencies to get their way, to push rules that might harm the business climate, might discourage investment and growth, and make life difficult, especially for smaller businesses. I think you're going to see less of that.
Okay, when you were speaking of one one industry, technology, which has been a target of FTC and DOJ moves for quite some time due to their market penetration. But can't the same be said for pharma and media?
Yeah, definitely. And we've seen the agencies in recent years bring cases against, for example, the blood cancer test developer Grail and the testing platform provider Illumina. They brought that case under the Biden administration, and the argument was that once this platform company buys the blood test company, they're going to limit the use of their blood test technology to the one platform. Um, Now, Illumina actually promised not to do that. They said, we'll sign a binding contract that requires us to make this technology available to our rival platforms. And if you can do that, we'd like to see the merger getting through. And the judge actually criticized the agency for, pushing the case forward without really considering that remedy. But by the time it got to the stage, the parties had decided to abandon the merger voluntarily, in part, and there's no official reason for this, but it certainly looks to be driven in part by the high cost of trying to push the deal through. And I think with the new administration, as much as you will still see the kind of targeting of these big firms in industries where there seems to be a significant amount of market concentration and power, I do think you'll see more pragmatism in terms of saying, okay, look, if you're willing to do X, Y, and Z, which would placate the concerns we have, then we are willing to say, okay, let this go. I think there's been less of that sort of, they're called consent decrees. There's been less use of consent decrees under the new current administration.
Right. So the point being is, going forward, lawyers who are representing some of these entities should think about this idea of being a little bit more creative in terms of the potential for alternative remedies or consent decrees, et cetera.
Yeah, absolutely. And also, look, especially in the pharmaceutical sector, IP issues are a huge thing, right? The current administration has had a number of attacks on patent rights in the name of encouraging more generic drug competition. Now, the thing is, it is a balancing act, right? Now, you can have lower drug prices with more generic entry, of course. But if you don't have the incentive to invest literally billions and billions of dollars in trials and approvals and so on, try and bring a new drug to market, those generic manufacturers have nothing to copy. And we've seen the FTC, for example, go after a lot of the patent listings in the Orange Book of the FDA, which includes a number of patented medications and so on, are saying these are faulty listings and they should be removed so we can have generic competition. We've also seen them push the argument forward that where you have a public-private partnership between a university and a large private firm that develops a patent, if the government is not happy with the price that technology is being sold at, it can march and take over that patent. So this is really unprecedented. It's a massive attack on IP rights, and it would be very counterproductive in the long run. And there are a number of foreign countries with large generic manufacturing industries that would love to see more of this sort of thing going forward, but we would hope that the new administration is a little more pragmatic and willing to say, we have to balance the interests of the patent practitioners with the patent holders. But it really is a question mark right now what direction the new administration will take on patents. It could go either way right now. Part of it hinges on who the appointees will be to the agencies, or the USPTO, for example.
Right. Now, so in terms of patents, yeah, pharma, that's a huge area. What about the companies like the major corporations, like technology, like media, like pharma, that operate global platforms? There's no question that anti-competitive actions and sort of antitrust related type issues and claims and regulatory actions have been going on lately, especially in the UK and China. Could you comment on that?
Yeah, sure. So it's really nothing new for other countries, competition agencies to come after big U.S. multinational firms, sometimes for purely political reasons, sometimes to protect their domestic local industry, and sometimes to basically extract wealth from big platforms and so on. So we've seen this in the very large fines that have been levied against Meta and other big tech firms in Europe and elsewhere. And what's interesting is that until recently, the competition agencies had tended to push back on some of that and try to export the US consumer-oriented, competition-oriented approach overseas because it benefits consumers and it leads to freer markets and so on. But more recently, we've seen a complete reversal on that. We've instead seen the FTC, for example, being accused of cooperating with European regulators to try and block mergers overseas that they could not block in the US. So, for example, there was a merger of Amazon and iRobot, which was abandoned eventually by the parties after the European regulators challenged it. The FTC didn't bother to challenge it because they realized they probably weren't going to win that in court in the US. But the threshold to challenge it in Europe is much lower. So right now, the House Committee on Oversight and Accountability is investigating the FTC for doing this sort of cooperation that basically damages American interests overseas. So we could see less of that under a new administration. Um, Also, the thing to keep in mind is that a lot of these countries, they have local industries that they seek to support. So, for example, in Australia, about 2 years ago or so, they passed a law that basically would force social media companies, platforms like Meta, to bargain with Australian news publishers to share some of the revenue that they receive from people clicking on news links on Meta's website, or from or looking at the thumbnails and so on. And this was clearly an attempt to help Australia's media publishing industry by getting some of the revenue that's going to these social media platforms. And it's been kind of strange to see, the US's own enforcement agencies kind of not really pushing back on things like that, because it clearly has kind of a protectionist angle to it. So we do expect to see more of this. And the final point to make on that is one of the trends we see overseas, which has gone against the kind of paradigm that has been established, is the use of ex-ante rules in the technology sector. So these are rules that hardline outright prescribe certain business practices that may or may not have anti-competitive implications. So in Europe, for example, you have the Digital Markets Act, and under that act, they want to pass a rule that would force Apple to open up its ecosystem and have more data sharing with apps like Facebook and so on in the name of increasing competition. And the problem is that could potentially lead to privacy concerns for Apple users who may or may not actually want that. And Apple has contested for that reason, because they said, look, we're trying to create a walled product that's different to other smartphones, and this kind of reduces that utility, our high security features and so on. Now, in the US, if the government wants to contest a practice like that, short of passing a law through Congress, they would have to challenge it in court under the antitrust laws, giving the business the opportunity to say, look, here are the reasons why this practice is still justified. Here's the value that it brings. We think that there are countervailing benefits to doing this that outweigh the perceived anti-competitive harms. You can't really do that in an ex-ante system where the government basically says, the agency says, here's a rule, follow it, or we're going to fine you heavily. It also leads to higher compliance costs for businesses operating overseas, which harms not just American tech firms, but their own local tech firms. And we've seen this with the impact of the global data protection privacy right in the European Union.
Okay, so we're coming down to the wire. We're coming to 30 minutes, and I like to keep these to 30 minutes. But essentially, you did an excellent job of summarizing and describing and articulating what's in the DOJ and FTC pipeline, some of the big cases, some of the main rules that the FTC's promulgated and passed lately that could be overturned or repealed, and the different and the sort of the impact it's have on mergers reporting and merger enforcement, as well as agency enforcement. So given that you're thinking and you're postulating that there'll be a more pragmatic, business-oriented approach to mergers and antitrust in 2025 when the Trump administration takes over and beyond, are you expecting mergers to increase again? And well, obviously, at least in the short term, because they have to inherit some of those cases, that the enforcement's still going to continue. But in terms of merger activity itself, are you expecting it to increase?
Yeah, I expect it to go up over time. Now, some of that will be counteracted by the new pre-merger notification rules, which haven't yet taken effect. And if they do end up taking effect, will take effect under the new administration. But I do expect an increase in merger activity across the board, especially given that cases that in the past would have been less likely to even get litigated in the first place are going to go back to not being litigated because they're less likely to succeed. I think that alone will lead to a lot of deals that companies have been kind of waiting on under the current administration. I think it'll lead to some of those deals getting back on the table.
Okay, so if I'm a business person contemplating a merger right now, it being December 19th, 2024, and the year end is December 31st, should I pre-notify about my merger or just wait? Like, I guess there's an argument to be made both ways, right?
I mean, I can't really advise on that specific situation. It would kind of depend on what the merger is and what's involved. But I think there is a wait and see approach going on at the moment. I think companies are kind of expecting and preparing for these new rules to go into effect and being ready to comply with them. But I think that's the best approach. Be ready for anything. They say it's going to increase the amount of time it takes to do a filing by about 68 hours on average. But keep in mind that for deals where there are overlapping lines of business between the two parties, or deals where involving private equity firms, which these guidelines scrutinize more carefully, that could take longer and the cost involved could be higher. So, we won't know what the full impact is likely to be for a little time. So, we have to wait and see. But be ready for anything. Anything can happen, and often does.
Well, Satya, you are just brilliant, and I'm really appreciative of this education you've provided to me and my listeners. I don't have any questions for you, but I do know that you have given us this information that is basically what's in the pipeline, what are some of these new rules, what's in the DOJ pipeline, and what are their emphasis, and that's going to continue in 2025 and beyond through the Trump administration at least. I want to thank you for that, and I want to invite the audience and listeners, if you're not following or connected to Satya on LinkedIn, go ahead and reach out to him at any time. I know I speak on behalf of Satya. I personally want to thank Satya again for being here, but I know both want to thank you all so much for coming, and we want to wish you all a wonderful holiday season and have a great day. Bye, Satya. Thank you.
See ya. Thanks.